about an offender's personal circumstances. It will remain the case, for example, that where an offender...
Good afternoon, Britain. Shabana Mahmood is speaking in the House of Commons about the sentencing guidelines. Let's listen in.
But it does prohibit the Council from making guidelines about pre-sentence reports with specific reference to the offender's personal characteristics, such as their race, religion or belief or cultural background. The bill will not affect the court's existing duties to obtain a pre-sentence report in appropriate cases, nor does it change court precedent around them, like the recent case of Thompson, in which the Court of Appeal noted the importance of obtaining a pre-sentence report in cases involving pregnant women or women who have recently given birth. Or the case of Meanley, where the court referred to the importance of pre-sentence reports in serious cases involving young defendants, or Kermakaj, where the court emphasised the defendant's traumatic upbringing, vulnerability and the fact that they had been a victim of modern slavery, as reasons why a pre-sentence report should be ordered. Judges will continue to request pre-sentence reports in cases where they ordinarily would, for example, those involving pregnant women and young people. I accept that this bill will, however, raise wider questions about the role of the Sentencing Council. The Council does important work bringing greater consistency to judicial decision-making. But we are here today discussing a question of policy, a difficult, disputed and uncertain one at that. If the government cannot determine national policy on the question of equality of treatment before the law, then we have uncovered a democratic deficit. Today's legislation exposes that question, but it does not address it. The proper role of the Sentencing Council and the process for making guidelines of this type must be considered further. I will do so in the coming months. It is right that this question is considered in greater depth, and should further legislation be required, I shall propose it as part of the upcoming sentencing bill. The Sentencing Council, while only 15 years old, holds an important position within the firmament of our justice system, and any changes must be made carefully and with due consideration. I am sure they will be discussed more in this House in the months ahead. Madam Deputy Speaker, the Government will today introduce the Sentencing Guidelines Pre-Sentence Reports Bill. The issue it contains are of great consequence because the path to a more equal society can only be paved by equality before the law. Again, I thank the Sentencing Council for putting a pause on their guidelines whilst Parliament has its say. I believe that we must reverse them and reassert that no race or religion should receive preferential treatment before the law, and the bill we will introduce today will achieve that. And I commend this statement to the House.
Shadow Justice Secretary Robert Jenrick.
Well, Madam Deputy Speaker, the Lord Chancellor must be living in a parallel universe if she's giving herself a pat on the back today. The truth is that she's completely lost control of the justice system. She sat on her hands for weeks. She took 7 days to gather her thoughts and put her views in writing to the Sentencing Council. Her incompetence took this down to the wire. Magistrates and judges were only updated by the press office of the Sentencing Council at midday today that the guidelines they were due to come into force had in effect been suspended. That raises the very real prospect that magistrates and judges sitting from 10 a.m. this morning were unaware of this chaotic last-minute change and did sentence people under guidelines that the Justice Secretary herself has conceded are two-tier. But it gets worse. In that very email to thousands of judges and magistrates sent just 90 minutes ago, the Sentencing Council state, and I quote, "We remain of the view that the guidelines are necessary and appropriate." Confusion reigns. They're being told one thing by the Lord Chancellor and another by the Sentencing Council. Who really is in charge here? Yet again, the Justice Secretary has been humiliated and undermined by activist judges seeking to undermine the will of this place, our Parliament. Her authority has been shredded. She is being treated as a two-tier, second-tier Justice Secretary. Madam Deputy Speaker, this was entirely preventable. If the Justice Secretary had simply put party politics to one side and just backed our bill weeks ago to restore accountability and empower her to actually control justice policy. But the Labour Party blocked it. If the Prime Minister has been tricked into sitting at the front of the Docklands Light Railway thinking that he's in charge, as his Chief of Staff mocked him for the other day, the Lord Chancellor has chosen to sit there in the passenger seat, allowing the judiciary to take charge. She's decided to be undecided. She's resolved to be irresolute, all-powerful to be impotent. Even after this complete shambles, she won't even re-establish ministerial oversight. We're told via frantic press briefings that her bill, which we haven't even seen yet, will surgically remove this two-tier sentencing guidelines. But this doesn't tackle the root cause of the problem at all, which is a legal quango that is activist, which holds views completely divergent to the public, to Parliament, and now we're told to the government. Unless she follows the formula of our bill, MPs on this side produced will be back here time and again to unwind the next piece of madness coming out of the Council. Take the Sentencing Council's immigration guidelines that water down sentences for immigration offences below the 12-month threshold for automatic deportation. If published, it will mean hundreds of illegal migrants and foreign national offenders will avoid deportation every single year. It will blow a hole in border security. It even waters down the maximum life sentence for people smugglers legislated for just under a year ago. It completely disregards parliamentary sovereignty. At our last exchange, the Justice Secretary said there would be no two-tier justice on her watch. Well, there it is. And it is worse than that. On the 2nd of January, her own department, not the Sentencing Council, her own department published guidance ordering the prioritisation of bail for ethnic minorities and transgender people, continuing a practice introduced under Gordon Brown. And contrary to the misinformation peddled by her press office, it produced new guidance on pre-sentencing reports that have been enforced for months, which state probation officers should consider the culture of an offender and whether they have suffered, and I quote, intergenerational trauma from historical events. Well, this is cultural relativism, which violates the rule of law and puts the British public at risk. And this time, nobody is to blame other than her. It's her department, it's black and white, it is two-tier justice. So I have some questions. Can she give the House the reassurance that nobody was sentenced this morning under guidelines that she concedes are two-tier? After he has brought the Sentencing Council into total disrepute, can she honestly say at the dispatch box that she has confidence in the head of the Sentencing Council, Lord Justice Davis? Yes or no? And if she does, is she aware that yesterday he took to the airways in an astonishing departure from the expected standards of judicial conduct to advocate for abolishing short sentences, especially for hyper-prolific offenders, effectively instructing lower courts to follow suit? It's time for him to go, and if she won't sack him for this, what would it take? Does she have confidence in Joanna Robinson, another member of the Sentencing Council, who took a moral objection to border control and described the Illegal Immigration Act as appalling? And lastly, will she change the guidance which her own department is producing, which has created a two-tier probation service? Or is it, once again, on her watch, two-tier justice under two-tier care?
Dear me, Madam Deputy Speaker, it seems that the Honourable Gentleman's case of amnesia is as bad as ever. 14 whole years appear to have disappeared from his memory entirely. He talks about parliamentary sovereignty, appears never to have known when his own party was in government, when he was a Secretary of State and a minister, what on earth parliamentary sovereignty is and how to exercise power. I think he's rather distressed that, in fact, my approach has led to a pause in these guidelines, and that I have brought forward a bill that will deal with the offending bit of this guideline, and that I'm going to consider the wider role and powers of the Sentencing Council ahead of the sentencing bill later this year. I understand it must be very disappointing for him that he has been exposed as someone who is all talk, no action, and I get the job done, Madam Deputy Speaker. I can see that it's annoying him greatly. Perhaps he would like to begin, as I often invite him to do so when we have our exchanges across this dispatch box, to apologise for the country, because after 14 years he appears to have never discovered anything of which he now discusses regularly from his position on the opposition benches. He did nothing about those matters when he was a member of the government that actually ran this country. Perhaps that's the problem. They didn't really run this country. They gave up on the job. He never rolled up his sleeves and put in the hard work to get the job done. That's why we inherited prisons on the brink of collapse, and that's why I'm now unwinding all of the mistakes that his party made and the guidance that they welcomed. The guidance that he and his party welcomed. He didn't tell me what discussions he's had with the Shadow Transport Secretary, and before they explain why they're so het up about things now, why did they welcome them when they were in office? There was no answer to those questions. So, Madam Deputy Speaker, I don't believe there were very many questions in that diatribe from the Shadow Justice Secretary. On sentencing, the pause in the guideline was communicated. That's a matter for the Sentencing Council. I will, of course, engage with the judiciary to make sure all is understood regarding the pause. Nothing has changed in relation to the ordering of pre-sentencing reports by judges in all the circumstances in which they ordinarily would. The guideline is what has been paused, and it will now not come into effect until Parliament has had its say. And also, Madam Deputy Speaker, he references two specific individuals, and this is the difference between me and him. I don't make it personal. I just focus on the job, and I get the job done.
Mother of the House, Diane Abbott.
I realise this is not a popular view in the House.
Well, we've been listening to a barnstorming back and forth in the House of Commons between the Justice Secretary, Shabana Mahmood, and the Shadow Justice Secretary, Robert Jenrick. Shabana Mahmood said she'll be bringing forward a short bill in short time in order to rectify what she calls two-tiered justice guidelines that have been now suspended by the Sentencing Council.
Yes, and Robert Jenrick, he had some tough words, didn't he? Calling her a two-tier, second-tier Justice Secretary, and saying, really, that it was all a little bit too late and they should have just gone with the bill that he proposed weeks ago. So there you go, a bit of a tiff there in the House of Commons, but it does look like this bill is being introduced, and that will be a positive.
Well, listening to it all was, of course, our political editor, Christopher Hope. So let's get the analysis now. Chris, this was a big seismic moment in the House of Commons. On the one hand, the government responding quickly. On the other, the opposition saying they haven't responded quickly enough.
Yes, hi Tom Amity. Yeah, a big moment, I think, for the Tory party. The first time the Tories have laid a glove really on Labour in recent weeks on a policy, of course, which started life under the last Tory government, allowed to happen, allowed to gestate, and then emerge 6 weeks ago with just a 6 week gap before it came in. And it would have been today to allow judges to take into account various characteristics on culture, race, gender and the like when sentencing someone in front of them, but not on issue of white man over 25. So I think, a real moment here for Robert Jenrick, showing how he is, of all the front benchers in the Tory party, the most effective, forcing Shabana Mahmood onto the back foot. They all agree that this idea is wrong. Shabana Mahmood has called it two-tier justice and did so there. But I think the slowness to deal with it is what Robert Jenrick was making clear there. Why not do this weeks ago? Why have this strange period of 3 or 4 weeks before the government can can pass a law to overrule what the council wants. I also think the future of the Sentencing Council chair is under question now. He is now being undermined by his own government, and indeed whether he lasts that long now is one for the future.
Mood, didn't he, there? And also whether no one has been sentenced under these two-tier guidelines is what he asked as well. I'm not sure he got an answer to that. It was just a strong back and forth. But what happens now then in terms of the legislation, Christopher?
Well, now it's being introduced. There's a couple of days wait before it can have its second reading. Then it goes forward. We are told by Number 10 yesterday that it won't be law before Easter. That's April the 20th, maybe shortly after that. But the Sentencing Council has spared the blushes of Shabana Mahmood. You wouldn't want to see 3 or 4 weeks of the wrong guidance being used in courts. That would have, of course, prompted immediate appeals for all of those. So that hasn't happened. And instead, there will be a pause while that happens. I think there's been a loss of face here. They've been slow to act by the government. They don't really use or recognise the size of their majority. They could have gone through the motions weeks ago. And instead, they wrote letters to and from the council. They replied, of course, on Friday saying we're not going to do it. I spoke to Keir Starmer in Hartlepool on Friday. He made very clear all options are on the table. And by Monday, the PM also told us they're going to take action, and that forced the hand yesterday and overnight of the Sentencing Council. So I think, again, they've been slow to act. They got there in the end. But all that's happening here, by the way, is that some guidance which all parties admit is wrong is being removed from advising judges, and that's probably the right thing.
And I suppose the row now becomes what the Labour Party is saying, a surgical removal of the offending text within the guidelines, versus what Robert Jenrick there was saying, an overhaul of the council, a responsibility for ministers going into the future. Because what Jenrick's speech there was moving on to, not just about these two-tier guidance, but about Lord Justice Davis and what he's been saying in the media. I mean, promoting policy off his own. Or Joanna Robinson, a member of the council, who called the Illegal Migration Act appalling. It sounds like the Tories are now shifting towards questioning the role and the powers of the Sentencing Council as a whole, whereas the Labour position is more surgical and targeted with this specific line that they don't like in the advice.
That's right. What they can do, I'm yet to see the full detail, it's just been published in the Commons, but they can amend probably Section 124 of the Criminals and Justice Act 2009, which means that rather than the council asking for advice from ministers, they can actually overrule it. I think that's where this policy will go, but it will take time. And I think the question mark over why the government appears to be happy to outsource the administration of bills published in the House of Commons when the judges are so far removed from what ordinary people think.